Hi, I'm Rachel Okello, a UK-based solicitor specialising in immigration, nationality and deportation law. I've been a solicitor since 2002, and since 2007, 90% of my caseload has focused exclusively on helping people who want to come to the UK to live, work, study, join family or do business. Today I want to talk about immigration detention and bail. So where do we start? Let's start right at the beginning, when somebody could actually be detained for immigration purposes. And that could be if you arrive at the airport in the United Kingdom, then you could be questioned by immigration officers. And at the time of them questioning you, you could arguably say that you are being detained for immigration purposes. So in the airport, they do have permission and authority to ask people pertinent questions to ascertain why they are coming into the United Kingdom. But the questions could go beyond that, and you could find that you are taken into a separate room and detained for immigration purposes, and even if it is decided to withdraw or cancel your visa or not allow you to have a visa to enter the United Kingdom, if you didn't need a visa but you were able to travel and get one from here, they could decide to not allow you to enter the United Kingdom and decide that you should return immediately back to your country of origin. And at that point, you may be detained for immigration purposes, awaiting the next flight. So on that occasion, you can make an application for an administrative review of the decision to remove you from the United Kingdom whilst you're at the airport. And obviously that will need to be done quickly, and it will certainly need to be done before the next flight takes place. But if you are detained for immigration purposes at the airport, then you do have an opportunity to make an application for an administrative review. And obviously your detention will end once you're either released from the airport into the United Kingdom or once you are removed back to your country of origin. Alternatively, you can find that you are accosted or apprehended by immigration enforcement either on the street. They do stop people in certain high pedestrianised areas. They tend to stop people when they're doing I could say a raid on a particular area of a street, or they could also stop you in work when they raid business premises to try and track illegal migrants who are working, and you'll be working illegally in the United Kingdom. Or they could enter somebody's home if they are aware that you are illegally in the country and they have your address, then they can enter your property with a warrant. And sometimes you find that they've entered a property looking for one person and they actually apprehend other people in the same house who are also without leave to remain in the United Kingdom. So they will then detain you for immigration purposes, and you should know that if you are walking on the street and somebody stops you and identifies themselves, they will need to identify themselves as an immigration officer. You don't need to stop unless they tell you that you will be arrested for immigration purposes, and you don't need to answer their questions. And it's very important because sometimes, and culturally, it's not always the case in every country that telling lies to the authorities, the immigration or the police will lead to severe punishment. But in the United Kingdom, whereas you don't have to say anything, if you do say something, then you need to ensure that what you're saying is the truth. So your two options are, don't say anything at all when they ask you questions, or what you do say should be the truth, and that could be used as evidence against you in the future. So if you are unclear, the best thing to do is to say nothing, and then if you need to do so later on, then you can contact a legal representative or a solicitor, a qualified immigration advisor, to come and give you advice. So if you are then detained for immigration purposes and brought to what they call an immigration removal centre, we normally just call them detention centres because it's where people are detained, but they are called immigration removal centres with the idea of removing somebody from the United Kingdom, then you can make an application immediately for bail. And you can make an application to the immigration Chief Immigration Officer. And you can also then, if that doesn't work, you will have the right to make an application to the Immigration Tribunal judge. And you can do that application yourself, or you can ask one of the charity organisations which help people to make applications for bail to do that for you for free. Or you can instruct a solicitor, such as ourselves, to make an application for bail for you, but that will have a cost attached to it. So some people do either use legal aid in the detention centre, or they use a charity who will do it for free as well. And applying for bail doesn't affect your actual substantive immigration application. So if you have an immigration application for leave to remain in the United Kingdom, that will still continue, and that doesn't affect you applying for bail. And even if you are in the detention centre, your application will still continue, and your bail application will be treated separately. So you shouldn't worry about applying for bail, or even asking somebody to do it for free, a qualified person who can do it under charity, or a legal aid solicitor who could be separate from the actual solicitor that's doing your case, because your real priority is to get out of detention. And I think that's the main thing. One, because you want to be free, and two, because it slows down the process of your application. So it stops making things so urgent, because even from the Home Office point of view, they have a duty not to keep people in detention for longer than possible, or longer than necessary, I should say. So if they believe that you shouldn't be in the United Kingdom, then they will try to fast track whatever they're doing with you to remove you from the United Kingdom, because at the end of the day they feel that you shouldn't be here and you shouldn't be in detention, and so therefore they will fast track your removal. So it is a good idea to apply for bail, to just be able to take the time and let the Home Office take the time to process your application properly. So you can apply for bail even though you have a substantive application ongoing. And you can apply for bail even if you don't have an application ongoing. But what you should bear in mind in that circumstance is if you go to a judge and say, well, I want to have bail, the judge may say, well, what for? Because you're not making an application. You're not motivated to report to the immigration authorities. If I give you bail, you may just disappear. So it's always a better idea to have an application in the Home Office before making the application for bail, and to have an application in the Home Office which is applies to your circumstances, not just a made-up application, to be fair, a proper application which applies to your circumstances and which has a good chance of success. And an immigration judge will look at your case thoroughly in terms of whether you should be released on bail. So being released on bail doesn't necessarily affect your application for leave to remain in the United Kingdom, and equally your application for leave to remain in the United Kingdom shouldn't affect the fact that you can be released on bail. So even if your application is quite weak, you should still impress upon the judge, if at all possible, that you can still be released on bail. Even though your application may on the balance not succeed, it doesn't mean that you need to be detained whilst this application is being processed. So there'll be a hearing and you'll go before the judge. You'll need to have at least 2 sureties, and sureties are guarantors who say that they will put up this sum of money, and if you abscond, if you breach the conditions of your bail, if you are granted bail, then they will be brought back to the judge to explain to the judge why they shouldn't have to pay the money that they put up in the first place, and they will need to show the judge that they were not involved and they couldn't help you absconding. But of course you're not going to abscond. So let's go back to the hearing. What the hearing will be about is the judge looking at the reasons why you shouldn't be detained. And there's a presumption that everybody has the right to liberty, and that's a human right. The judge will also look at your ties to the community. So if you have a family life, then you'll need to show that to the judge that, you know, I am motivated to stay in this area, and I am motivated to stay within the conditions of my bail and to report to immigration and not to abscond because I have a wife, or I have my mother here, or I have children, I have a partner, I have lots of friends, I have lots of things that I do in the community. And you can bring those people to the hearing and you can produce evidence that you have these links to the community. If you have property in the United Kingdom, if you have any ties to the United Kingdom, then you need to show that to the judge. You need to really convince the judge that they can let you go on bail and you will not abscond. And that's the main thing that you need to focus on, because the main thing the Home Office wants to know is that if they decide to remove you, or they're successful in their application or their attempt to remove you, that you will be available for them to be removed. You'll be available to them to be removed, and you will not have disappeared into the system. So that's what the judge will want to know. The judge won't want to know that you've absconded after he has given you bail. And I also want to just highlight that if you are somebody who has a criminal conviction, so you're being released from prison and then you were detained after your prison sentence for immigration purposes, you can apply for bail as soon as your prison sentence finishes, even if you're on licence. But you will need to liaise with the probation services so that your address that you're going to go to can be approved by the probation officer. And you need, in addition, to have evidence that you're unlikely or have a very low risk of reoffending if you are released on bail. So that's really how to get out of immigration detention. If you are detained for immigration purposes, you have an immediate right to ask immigration to release you. And if they don't release you, then you can make an application to the court for bail. There isn't a court fee. There isn't a requirement to have legal advice, but I think if you can get legal advice, then it's best to do so. And there are lots of charities that offer bail application representation for free. We also offer it as well, but we offer it obviously as a cost. We're solicitors after all. So that's it. I hope this has been useful. Certainly, if you've got any questions, you can contact our office. We do also offer a free case assessment as well. So if you are in detention, or if you know somebody who's in detention, you can contact us in the first instance and we can tell you whether that person's likely to get bail, whether this is the right time to apply for bail, because if you apply for bail and it's refused, unless your circumstances change, you won't be able to make another application for 28 days. So it's important that when you apply for bail, you do so correctly and you do so at the right time. So if you've got any questions, you want a free case assessment on this or any other immigration issue, then certainly do make contact with us. You can follow us on social media at Rogals, which is ROGOLS. Our website is rogals.co.uk. We are on Facebook, Twitter, LinkedIn and YouTube. And our office number is 0121 3 894 895. And if you are out of the country and want to talk to us on WhatsApp, then we're on 07895 327 049. So it's been nice to connect with you today, and do certainly keep in touch. Thank you.